On today's episode of Secured Steps, I'm joined by Ryann Siclari, an accomplished special needs planning attorney and a passionate advocate for individuals with disabilities and their families. Ryann is a certified elder law attorney, which is a distinction granted by the ABA accredited National Elder Law Foundation. In 2024, she was honored with the Joseph B. Young Excellence in Legal Advocacy Award as part of Disability Right New Jersey's Impact Awards, a major honor and really a testament to the hard work that she and her team do. Today, she brings her deep expertise in estate planning, guardianship, and public benefits to help us navigate the legal decisions that can shape a more secure future for our loved ones with special needs and our elder community who could be at risk. Ryann, it's so nice to spend time with you today. Thanks for joining.
Thanks, Jeff. I really appreciate it.
Tell our audience a little bit about who you are and a little bit about your practice.
Sure. So, as you mentioned, I'm a certified elder law attorney, but one thing you didn't mention is I also have my master's of law specializing specifically in the area of elder and disability law. So, a couple of other unique credentials that I have. So, my practice is in Morristown, New Jersey and Clinton, New Jersey. So, sort of depends on if you believe in central New Jersey or not, but the central to northern New Jersey area. And though I do practice all over the state, one thing that came out of COVID is a lot of stuff is done virtually these days. So I do practice all over the state. But as you mentioned, my expertise lies in the area of special needs. So dealing with the population under the age of 65 with disabilities. And I also deal in elder law, which is sort of the population 65 and older, and how both sets of individuals navigate these eligibility issues as it relates to different government benefits, paying for care, and ensuring that their care needs are met.
So you really kind of serve a wide range of disparate needs, I would say, right?
Yes.
Well, before we dive into your practice and the legal brain that you have, let's start on the personal side a little bit. Anything interesting that you're reading right now?
It's funny. There is no in between in my reading. I read first grade books because I have a 6-year-old daughter. So I think I read Waiting is Not Easy recently. And then I read legal books. So there is no in between in my reading right now. It's either first grade novels or legal novels, and no personal reading just because my schedule is so busy. A 6-year-old keeps you involved.
Absolutely. And when my daughter was young, I had 2 or 3 books absolutely memorized from bedtime routine. Any book you have memorized?
Where is the green sheep? I think I could do front to back, left to right, and probably sideways.
For me, it was Goodnight Moon. I could quote that thing. I still see that book in my sleep.
I think I could do that one too, actually.
So on the legal side, what do you read a little bit?
I as embarrassing as it sounds, I enjoy reading case law. So one of the things that keeps me sort of abreast of what's going on in my practice area is cases. So when a situation is brought to the administrative law court or the Superior Court of New Jersey or the Appellate Division of New Jersey or even the Supreme Court of New Jersey, there are opinions issued by these judges on how they decided cases. And those opinions really color how I practice my work, right? Because if they decide something a certain way, it might change what I need to do for somebody, or it might just further reinforce what I'm doing. So I read those regularly, and I enjoy that reading because it's to me, my practice area is something I enjoy and love to do. So I enjoy reading those.
Nice. Well, I'm sure it serves everybody for you to have that knowledge, but I'm going to leave that reading to you because I don't know. I think I'd rather read Goodnight Moon than case law.
Yeah, you and a lot of people.
Yeah. Um, I'm a big habit guy. People have listened to me and know that I love to talk about habits. I find daily habits are interesting to learn a lot about a person. So I'd love to hear what's a small habit that you do in your life that has made a big difference for you.
So for me, I am an early riser. And I think that that is a good habit that has helped me sort of get into a routine. I get some alone time in the morning before the rest of my family gets up. I can have my coffee. I can, if I want to just scroll the internet and do some mindless things, I can do that and sort of not have any guilty feelings because I'm not taking away any time from anybody else. So for me, being an early riser is a habit that I have, and I don't think I could do without.
Interesting. I'm also an early riser. My team here at Rockwood knows if you want to come to me with a complex situation, it better be before lunch because after
Yeah.
lunch, this brain starts shutting down a little bit.
I'm the same way. Don't email me at 7 o'clock at night. You're not going to get a response.
You're not going to get like this well thought out thing. So, a word to everybody that works with us: hit us in the morning for sure. What's a piece of advice that you ran into your life and really you reflect on, or that comes back to you? You know, a good piece of advice.
That's an interesting question. So, I mean, I'm sure everybody has had a whole host of advice that they've received over their lifetimes from various people, but I think one of the pieces of advice that I have to remind myself of on occasion, right, is don't react immediately. Um and sometimes when you react immediately, you find that you're overreacting. So maybe you draft that email, but don't send it right away and think about it for a day or two before you make a response. So I think don't react immediately is good advice. It can allow you to avoid some uncomfortable consequences if you really sit and think things through more thoroughly before you jump to a conclusion or jump to a reaction. So I've found that to be a really good piece of advice.
I think that that's powerful because we spend so much time in our day, particularly parents and professionals, kind of firefighting, right? Going through the day and going from one emergency or semi emergency to the next. And we have to find that space. So it sounds like you find that space early in the morning for deep thinking. And then you try not to be too reactive and act too quickly with email and
I
communications.
try. I try. I really try. I'm not always successful, but I try.
Well, good piece of advice for us all to keep in mind. Let's start turning toward your career and the work you do. How did you get into this? Because the things you do for families and the advocacy, it's such important and critical work, but I know it can be very emotional and very uplifting when done well, but it's got to be a calling on some level. So tell us a little bit about how'd you get into this line of work?
Believe it or not, there is an element of I fell into it in a way. It was not something that when I went to college or I went to law school that I had always dreamed of being an elder law attorney. It was not on my bingo card, so to speak, when I started these things. But when I graduated law school, I had an opportunity to go into Social Security disability work. And I took that opportunity and it was sort of eye opening, right? It was like, this helping people. That's what I was supposed to do with all this education. And then, now that I sort of just grew from there, but now that I think about my history a little bit more, I don't think it was total happenstance. My father is a 100% disabled veteran. So I, have that experience in my life and helping him and seeing what he's been through. My grandmother actually helped bring over the hospice program from England to Delaware when she was a nurse at the University of Delaware. And so, like, it's sort of in my history more than I even realized, I think, at the time. And so I think I just got lucky in a way that I took a job and then sort of it made me realize that that was really what I was supposed to do. So I got lucky, frankly.
Thank you to your father and your family for your service. We appreciate that. Let's talk about Social Security disability, right? If that was your foray, your entry into this line of work, what was that like?
So it was my first job out of law school. I had no idea what I was doing. I was a baby lawyer, and it was a great practice area to start in, given what I do now, because it gave me Social Security is sort of a baseline for a lot of the work that we do for the special needs world. Many of my clients are on Social Security disability or supplemental security income. And the rules for those programs play into my practice today. What are the eligibility criteria to get Social Security disability on your own work record, on a family member's work record? Those are things that I learned in that work that I use today. So I don't necessarily file file for appeals for disability determinations based on someone's level of disability, there are specialists that do only that. So we let them do that. But if somebody has a financial issue, right, they don't financially qualify for supplemental security income, that's where I can help them the most, because the disability people don't necessarily know all the financial rules. But because I was doing the disability determinations and then did the financial determinations, I sort of have a more well-rounded view of these eligibility rules that I wouldn't have had if I didn't do that job first. So it was a great experience. I knew that I didn't want to it was very siloed. The thing I was doing were appealing disability determinations because that was the practice area. I wanted more than that. So that's sort of what led me to move on from that position.
It sounds like that little kernel kind of blew up into a whole bowl of popcorn, given the wide
It's a
range of
great way
issues
to
that you
put it.
deal with.
It's a great way to put it.
Well, let's separate this a little bit, because earlier you talked about you serve the under 65 community and the over 65 community. So I'd love to spend time in both places. Let's start in the under 65 community. Tell us a little bit about your work in that world.
Sure. So I think most people refer to the under 65 community as the special needs area of the law. And really, we're just talking about people with disabilities and they are under the age of 65, and what areas do they need support in? And so most often we're talking about eligibility for various benefits that are going to give them monetary compensation, right? Because they need money to live on, and it's going to give them medical services, right? They need um, treatments, they need home health aid or personal care assistance, they need private duty nursing. So, what services, they need housing support, which programs are going to give them the most well rounded support system? And so that's sort of the special needs planning area. And so my job is sort of to get them in a position where they're eligible for all of these things. And a lot of times the issue comes in is financially qualify for these programs because they are primarily means tested programs. And when I say means tested, I mean, they're looking at your money, and means typically means your income and your assets or your resources. How much money do you have in the bank? And so we've got to make sure that between that income and those resources, that you meet the eligibility criteria to get the SSI, potentially, to get the Medicaid, to get services through the Division of Developmental Disabilities, so that you can get the housing, the medical, the monetary compensation. So that's sort of the special needs area of the practice.
So, as you know, I'm the father of a adult daughter with special needs. So this world really matters to me and something that I had to learn about, but you see all the time, and you've worked with, I don't even put a number on it, how many families you've worked with. What's the typical first conversation, right? Why do families seek your counsel? What are they kind of dealing with? And just tell us a little bit about that.
Yeah, I think the vast majority of families that come to me are coming to me around the time that their child is turning 18. Now, sometimes I get people who come to me sooner because they're experiencing some issue with their medical. They're not getting a service that they were getting. But a lot of times they come to me around the age of 18 because things are changing for that person, right? 18, they're a legal adult. And so we've got to now look at a whole host of different things at the age of 18. So that's usually when families start coming to me is they say, the school, my friends, other people in the community that we meet, we have caregiver meetings, family support meetings, and somebody said I need to start talking to a lawyer at this point. And that's sort of how that first starts, which is great because now I can say, okay, they're getting ready to become a legal adult. And I can just tick off all the things we need to be considering to get this person in the best possible position for the rest of their life.
Yeah, as I think about a minor with disabilities becoming an adult with disabilities, a few things come to mind for me. I'd love to kind of go into each of those with you a little
Sure.
bit. The first is probably decision making, right? Because we know when they go from kids to adults, they're a legal adult. Sometimes the parents want to retain control of some decisions to protect their child, or maybe they're concerned about the child's ability to now make decisions on their own behalf. So, what conversations should families be having around guardianship, powers of attorney, supported decision making for their teenagers and young adults?
I think the most important thing that families need to consider is that it's not a one size fits all approach, right? Not every single person with disabilities who is turning age 18 needs a legal guardian. It's an individual specific analysis, right? What decisions is that individual capable of making on their own? Are they able to understand when take in the information, process the information, and render a decision on certain things, legal, medical, financial? Are they able to do that? Are they able to do it with some support? We call that supported decision making, right? Are they able to, if somebody gives them a little extra help in analyzing something, are they able to then render a decision? Or are they just not going to understand all of these factors? Are they analysis paralysis, as they say, and not be able to render a decision? Do they just not understand? So every single family, we've got to do a case by case analysis of that person to see which approach, because if the person is able to make their own decisions, then we don't need a guardianship. Maybe we say, you just need a power of attorney, because like any person who's the age of 18, you could get hit by a bus tomorrow, right? And you would need somebody to help make financial decisions for you. So if that's the case, then a power of attorney may be appropriate for somebody. But if they're not capable of understanding what even a power of attorney is, now we got to lean towards guardianship. So every family is going to be different, and we're just going to have to do a case by case analysis. But you have to have the conversation, right? Because it's not a one size fits all approach.
Yeah, I that rings true for me, certainly in my experiences there. If a family decides that the solution with your counsel is to go for guardianship, what does that look like in New Jersey?
Sure. So New Jersey has, I think, a very good guardianship system. There's been a lot of guardianship backlash over the last few years, Free Britney movement. And then there was the Netflix documentary. I think it was called I Care a Lot. There's a lot of backlash in the guardianship system that people aren't getting appointed inappropriately. And like absconding with people's money and taking advantage of them. So I think that there's a lot of negative media about guardianships right now. But I will say I don't think New Jersey falls into that category. We have a pretty robust guardianship system here. So the way that it works essentially is you start with two doctors would certify in specific physicians' certifications that they, in their analysis, believe that the person is incapable of making legal, medical, and financial decisions on their own, or some combination thereof, right? They may say they can do this, but not this. So that would be the difference between a plenary or full guardianship versus a limited guardianship. We can do that here. And so the doctors would render their opinions, and then an attorney like myself would file with the court to say, we think this person is incapacitated, meaning that they can't make these decisions for themselves, and here's our doctor's certifications to support that conclusion. Then the court will assign an attorney to represent the alleged incapacitated person. They'll have their own lawyer. That's one of the things New Jersey does really well to make sure that that person is protected. So their lawyer will represent them in the guardianship hearing. And if they tell their lawyer, I don't need a guardian, it's their job to contest it. So we have a really good system in place to make sure that guardians aren't appointed for no good reason, that it's an appropriate appointment. And ultimately, if it's not contested, right, the court-appointed attorney determines that it's appropriate as well, then we ultimately end up with a guardian appointed by the court in a court order.
So glad to hear New Jersey is better than what I've seen on Netflix. Let me put it that way, because I've certainly seen other states where it just seems to be not modern and not flexible enough. And I know you need some rigidity as well, but not flexible enough to actually give the support we need, right?
Exactly.
Let's go back to basics a little bit, because I don't know about you, but the biggest, or rather the most frequent question I get from families when they first kind of walk in my door: what's an ABLE account? What's a special needs trust? Why do I need these? Why do I not need these? And you talked about means testing benefits earlier. So I'd love if you could teach us a little bit about an ABLE account, how that works in New Jersey, as well as different types of special needs trusts.
Sure. So let's start with the ABLE account. ABLE stands for Achieving Better Life Experiences. It is a 2014 law, federal law, that essentially created this type of account where a person with disabilities can put money into the account, and that balance is not considered an asset for purposes of applying for supplemental security income or Medicaid. Now, there's a whole bunch of rules surrounding it, right? The person who creates the account has to have been determined disabled prior to the age of 26. That's actually increasing to 41 in
Yay.
January of 2026. So that's great news. It's expanding soon. So
And
there
that
has to
needed
be,
to expand.
oh my
Yeah.
gosh, did it? Because there's people who develop disabilities after 26 who were precluded from using this device. So it needed to happen. It was a good thing. But it doesn't come into effect until this coming January 2026. So person was disabled prior to the requisite age is part of the requirement. And then so once they establish this account, there are limitations about how much you can contribute. So you can only contribute up to the gift tax exclusion each year, which this year is $19,000. So from all sources, whether I put money in there, the person with disabilities puts their own money in there, Jeff, you put money in there, it's total 19,000 for the year. That's the maximum annual contribution, at least for 2025. And so that money can go in there and it doesn't count against the person. They can have it and they can still qualify for these benefits. They can use the money for qualifying disability related expenses, which is pretty broad. It can be used for rent, it can be used for food, it can be used for assistive devices. So it's pretty broad actually on what qualifies as a qualifying medical, like disability related expense. So you can use the money when you need it, but you're not scrambling to use the money when you don't want to, to get benefits. So the ABLE account is a really great device when we don't have too much money we're trying to deal with. You know, a small inheritance somebody received, they accumulated a little bit too much money to qualify for the program they're on, and we just need to get rid of some of it, but we don't want to just blow it. It's a great place to store it till we need it. There are some limitations about the total amount you can put in. For SSI purposes, supplemental security income, you can only have $100,000 in the account. Then it starts counting against you after that. Medicaid doesn't have the same limitation, but a lot of times the two programs are interrelated, so I generally try to keep it under the 100,000. But one of the downsides of the ABLE account is it has what's called a payback provision. So anything that's left in the account when the person passes away would go to pay back Medicaid for benefits that they paid for the person during their lifetime. So the goal of the ABLE account isn't necessarily to create some huge savings account. It's really to place the money and be able to use it when you need it. So that's sort of the ABLE account. The Special Needs Trust has a similar function in the sense that it takes excess resources, money that is disqualifying a person from benefits, and puts it into a trust that is not a countable resource against it. That's the big picture. And what we're talking about is called a first party special needs trust, because there's also a third party special needs trust. We'll talk about that in a minute. But the first party special needs trust, what makes that one special is the federal law says that if you meet certain criteria, we're not going to count it against you. So what are those things? Well, first, the first party special needs trust has to be funded with money belonging to the person with disabilities. So if they, again, I like to use the example, come into an inheritance, mom or dad, grandma, grandpa, they didn't have a will, or their will said, I give the money to my child, and didn't have any other planning. That money, then they pass away, that money belongs to that person. It's theirs. It has what we call in the legal world vested. It's theirs. At that point, I can't just get rid of it. I have to put it into some device, and the way we can do it is a special needs trust. So that's money belonging to the person. Another common example is personal injury settlements. They get injured, they receive money from this injury settlement, That's their money that can go into the first party special needs trust. So it's just a couple of examples. But what are the criteria? Well, the person has to be a person with disabilities as determined by the Social Security Administration. The trust has to be structured so it's for their sole benefit, which is sort of, you'd think that would be easy, but they really scrutinize this quite strictly. So I'll give you an example. You have a trust and it makes a distribution for rent on a house. Well, who lives in the house? Is it just the person with disabilities, or is it mom and dad and the person with disabilities? If you pay the rent for the whole house, is that for their sole benefit? The answer is no. So we have to be very cautious about distributions from these trusts to make sure they're truly for the sole benefit of the beneficiary, which is the person with disabilities. The other criteria include that the trust has to be established and funded, meaning the money goes into it prior to the person turning age 65. So 64 and 364 days, we're good. 65, no good. So we've got to be very cautious about when we create and put money into this trust. And so this all sounds really great, right? Okay, great. You got this extra money, you put it in this trust, and you qualify. Woo, we're good. The downside of this trust is that it has what's called a payback provision, which means that any money left in the trust when the person passes away goes to pay back Medicaid for benefits paid over the person's entire lifetime. And that could be the entire balance of the trust, depending on what kind of, how long the person has been on Medicaid, program they were on. That could be a lot of money. DDD also has a lien. So if the person is on Medicaid and DDD, now we've got two entities we're paying back for services over the person's lifetime. And so a first-party trust is not an ideal way to plan, but if we are in a situation where our person with disabilities has money, it's their money, it's a tool that we can use to make sure they don't lose their benefits or that they get to keep them.
And that's such a key part there between first and third party trust, and why estate planning for the parents or the grandparents is so important. Because I don't know about you, but one of the biggest kind of traps I see or mistakes is a family lands in my office because the disabled adult has inherited a bunch of money outright because there wasn't kind of a thoughtful plan above them as far as how to give money to a trust. So really appreciate the explanation there of how to set up the trust and the criteria. Super, super helpful. When somebody establishes a trust, let's say they've sat in your office, worked with you and your team, they've got a third party trust set up. One thing they have to do is figure out a trustee, whether it's the parent, an uncle, a corporate trustee. What qualities do you recommend families look for when they're trying to figure out who's going to be the trustee for this new special needs trust?
That's a great question. In my own mind, I have sort of some criteria that I always look for. And I don't know that this is not in order of priority in any way. I think they're frankly an all equal priority in my mind. But I think it needs to be somebody who is trustworthy, right? We don't want somebody who is taking from the trust inappropriately. So they need to be trustworthy. They need to have some element of financial savviness, right? Going to be taking this money and they're going to be investing it and using it. And they got to have a sense of, look, this money needs to last for some period of time. Are we using it too quickly, too slowly? So we need some element of financial savviness, and they got to understand the government benefits rules. Because if you make an improper distribution, it's not just a, oops, my bad. It's a, oops, my bad, and this person lost eligibility for Medicaid or DDD, and that means they lost their, potentially their home health aides, potentially their housing vouchers. I mean, it could be mistakes in this space can be catastrophic. And so that, you know what, I take it back. That would be my number one criteria, is that they have to have a sense of the understanding of these programs. And so while I think that family members can serve in these roles, they need to have proper counsel. They can't do it without help from financial advisors, from lawyers, from people who understand the things that they just don't have experience in. Through no fault of their own, right? It's my job. It's not your job, right? And so I think then the other criteria is longevity, right? Okay, fine. You have a family member do it. What if I have a very young person with disabilities and an older person serving as trustee? What's going to happen when that older person who's serving as trustee can't do it anymore, or they have their own things going on in their life that prevents them from giving it the devotion that they may need to, because it's a job. Being a trustee is a job. And so I think we have to take all those things into consideration. And so for some families, we have a really quality line of individuals who can serve. For other families, we don't. And so there's an appropriate place to have what we call a corporate trustee, which is, a financial institution or a company who specialize in serving in this role. They know the rules, so they're less likely to make errors that are going to jeopardize somebody. And frankly, they're insured for it. So if they do make errors, we have some recourse, whereas with individuals, we really rarely do.
Yeah, I appreciate that perspective. Pulling that team together is so important in these situations where we have families with loved ones with disabilities. It's who's the advisor, who's helping you do the planning, who's drafting, who's your attorney, who's the advocate drafting that special needs trust. The trustee comes in, sometimes a trust protector, an insurance agent. You name all of these components that are tied to the formation and funding of a trust. And it takes a village. And we got to make sure we have the right people in place to support that family here and for the long term. I could talk about this part of your practice for days. I want to hear about the other side of the practice, your kind of over 65 clients.
Okay,
Talk a little bit
sure.
about that.
Sure. So, I told you the special needs trusts you can't fund once you're 65. So that option of saying, well, I've got this pot of money that's disqualifying me, let's put it over here. I don't have that option once somebody turns 65. So I have to look at different techniques to deal with these assets to get these folks on various benefits programs. And so when we're talking about the over 65 population, it could be a person who's had lifelong disabilities, or could just be a senior who has aged and now they've developed Alzheimer's. They've just physically deteriorated because they're 90, and who wouldn't at 90, right? So it's a different set of rules that we have to consider. When I meet with families who come to me, it's typically a senior who has um, experienced some sort of health crisis, a stroke, Alzheimer's. They're now to a point where they need some sort of care, whether that's home care, they need a home health aide, they need to be placed in a nursing facility or an assisted living facility. We're really looking at Medicaid as one of our payer sources, because when it comes to long-term care, there's not that many ways to pay for it. And so we're either paying out of our own pocket, which is private pay. Maybe we were lucky enough to have purchased a long-term care insurance policy that we've maintained. Not everybody has, but maybe we did. Medicare is not going to cover long-term care. Medicare covers rehab. It covers a short-term period to recuperate from some medical situation, but it's up to 100 days maximum. You're not even guaranteed the 100 days. It's up to 100 days. So we tick off all these things. Long-term care, Medicare is not going to cover that much. I've got two options left: pay out of my own pocket or see what I can do to get Medicaid. And so that's sort of where I come in, is to try to engage in asset protection strategies so that we are minimizing the private pay piece to try to get people eligible for Medicaid to cover that expensive cost of care. I have quite a number of strategies, and it's so specific based on individuals' financial circumstances that it's almost impossible for me to tell you all of the planning techniques. But a couple of things I'll just give you as pointers. One is Medicaid has what's called a 5-year look back. So when you apply for the long-term care Medicaid program that we would need for nursing facilities, they're going to do a 5-year audit of your finances. Why today? It's July 2025. Or I'm sorry, June 2025. They're going to go back to June 2020. Between June 2020 and June 2025, they're going to ask you for all your bank statements. So you can go through them line by line to see if you've given away or transferred any amount of money to anyone else. And if you did, they're going to give you a penalty, which is a period of time that they're not going to pay for anything. And so we kind of use that to our advantage in planning. Before 5 years, then they're not going to give me a penalty. That's the gold standard, is to plan ahead. So if I did my planning in May 2020, I created an irrevocable trust. I transferred certain assets to it for asset protection purposes. Now I'm applying in June 2025, more than 5 years after I did that. They're never going to see that. They can't say anything because I did my planning ahead of time. That's the gold standard, right? But some people don't do that, right? And we end up in what I call a crisis situation where we didn't plan and now we need long-term care. What do? We still have options. And essentially, it's going to be client by client specific. It's going to depend. Are you in a nursing home? Are you home? Are you in assisted living? Because the rules are different for each one. But the bottom line for you to take home is that don't assume there's nothing you can do. I think a lot of people assume that, well, I didn't do any planning. I'm in the nursing home. My spouse is in the nursing home. My mom, my dad, somebody's in the nursing home. And the nursing home is saying, you got to spend all your money before you can apply for Medicaid. That's the rule. That's not the only choice. And so I would encourage you to have an analysis done about what your options are, because in most situations, I can protect something. Your only option is not to just spend your money at the nursing facility.
I love that. I love how you think about every situation a little different. There are nuances here, but also to those listening, even if you know you're a little late, that doesn't mean you give up. You seek
Exactly.
out expertise, you find the solution that's available for your situation, and it's a really powerful thing. Ryan, it's been a great chat with you. I know our conversations have always I've always left the conversation smarter than when I arrived. So I appreciate the insight into New Jersey concepts. How do clients typically find you, connect with you, work with you?
Sure. So there's a number of ways. One of the easiest, you can go to one of our websites is Porzio Planning. It's Porzio, PorzioPlanning.com. You can see some information about me and some of my partners on that website, or you can contact me directly. My phone number is 973-894271. Give me a call. I'd be happy to meet with you and discuss your particular situation and see what we can do to address your whatever you're experiencing. And if frankly, if I can't help you, I can put you in contact with somebody who can.
Right. Back to our theme of it takes a village.
That's right.
And something I know about you, having worked with you before, you're a connector. You help families find the right place based on their situation. So that's certainly something that I've always appreciated about you. Any kind of closing thoughts you want to share with the people out there?
I think that keep doing what you're doing, right? If you're dealing with a person with disabilities or a senior who's experiencing health issues, it's a hard job that you're doing, right? And you're doing a good thing for that person by being supportive of them and figuring it out. Not everybody has those people in their corner. So keep doing what you're doing, get the support you need. And whether that means reaching out to attorneys, financial advisors, care managers, getting an aide in the house because you just need a mental health break. Don't forget about you, and keep doing what you're doing.
I love it. Keep doing what you're doing. Ask questions, find experts, and build your village around you. Ryan, it's been so great spending time with you. Look forward to our next chat.
Thanks, Jeff.